Okay, at this point we may as well get started. If a few other people join us late, that's fine. But I want to make sure we have the full hour here because we have a lot of information to be giving you all. I will be presenting with Megan Shaked from our California office. So I'm here in DC. This is Jordan Schwartz, and Megan is in California. And I will be discussing the first half of the presentation on website compliance with the ADA. Some of you may have heard me speak on this topic before. This seems to be this is such a hot topic. I am getting calls from clients all throughout the country every day on ADA website compliance issues. Unfortunately, multiple lawsuits every day against places of public accommodation. So this really is something you want to be aware of and really take as many precautions as possible. For the first 25 minutes or so, I will just give you the lay of the land about ADA website compliance. I'll talk both about compliance from a WCAG perspective, and if you don't know what that is, I'll explain it, and then just compliance generally with the ADA regulations. And that'll last about 25 minutes or so, and then Megan will take over and she'll talk about a few quicker topics, service animals, which we continue to get questions almost daily on issues surrounding service animals, issues relating to food allergies, and effective communication strategies with issues relating to individuals with visual and hearing impairments. As you hopefully can see in the chat box on the left-hand side, that is our question box. So if you have any questions, please feel free to type them in the chat. Depending on how specific the question is and how the presentation is going, either Megan or I will attempt to answer during the presentation, or if we run out of time, we will take a note of the questions and we can see who sent them, and then we will respond to you individually when the presentation is over. And with that being said, we have a lot to talk about, so I'm just going to get started right away here. And in talking about website accessibility, the first thing I like to say in many of these presentations is, I'm the lawyer. I'm the one who's advising you how to limit your liability as much as possible and reduce your legal exposure. But I also just like to say, from a practical perspective and just being almost a good company perspective, this matters in other ways too, because the culture of your organization certainly does make a difference. And you want to think about, again, aside from limiting your legal exposure, the more you can make your website and your property or your store, or whatever have you, the more you can make it accessible, the more you can set a culture that emphasizes the accessibility of your company, of your services. And not only is that just a good thing to do, there's actually a pretty good business case that making your website and your property accessible could increase profitability. It certainly can improve your brand and widen your customer pool. It's certainly not a bad thing if you're known as a place of public accommodation that actually is accommodating to individuals with disabilities. So I always like just throwing that out there first. Now back to putting on more of my lawyer hat here, and I can't talk about ADA website issues without just giving you a brief overview and background of Title III of the ADA. Most of you will know about this, so this might be a little background, but it's just always important to keep in mind. I was talking to a new client the other day who said that they heard that these issues do not apply to them because they have less than 15 employees, and thus the ADA doesn't apply. And I had to explain, that's Title I of the ADA. That's dealing with employment issues, and that has absolutely nothing to do with public access law under Title III of the ADA. The only time Title III of the ADA doesn't apply, arguably, is if you have an extremely small property, a bed and breakfast that has 5 rooms or less with the proprietor living on the property. Then there's a very good argument that you're not considered a place of public accommodation. But otherwise, for stores, retail services, restaurants, hotels, you will be covered by Title III of the ADA. And what that does, Title III, prohibits discrimination against individuals on the basis of their disability with regard to their participation and equal enjoyment in the place of public accommodation. So, if they're going to a grocery store or if they're going to a hotel, they need to be able to participate in and enjoy that place just as someone does who doesn't have a disability. Over the past decade or so since I've been doing this, these issues have typically arisen in brick and mortar situations, like at your property, lack of accessible parking spaces, potentially having ramps that aren't don't meet the ADA standards, bathrooms that don't have the required grab bars and things of that nature. That's what's happened in the past, and this has been a law since 1992, and it applies to owners and operators, landlord tenants, franchisors, franchisees. It requires to all public accommodations. And when this law was implemented, certain regulations were implemented as well. And those regulations were then revised in 2010. And in 2010, they added a whole host of additional requirements, and that is the basis of the ADA website issue that I'll be talking about today. So just keep that in mind going forward. Just a little bit more about Title III of the ADA. I keep on saying places of public accommodation. Hopefully you all know what that is. It's, again, hotels, resorts, spas, restaurants, grocery stores, golf courses, anywhere that the public is invited to come. And again, Title III requires all hospitality owners or all owners of such places of public accommodation and operators to maintain facilities that are accessible to individuals with disabilities. So if you're an owner or operator, you must make your goods and services available to and usable by individuals with disabilities on an equal basis with members of the general public. And you also need to make reasonable modifications to your policies, practices, and procedures when necessary to serve customers with disabilities, so long as such modifications are not an undue burden on your business. And these are some of the things that Megan will actually be talking about a little bit later. I'll talk about a little bit through the website how you need to remove barriers to access. But in terms of the modification of policies, you might need to have auxiliary aids and services for effective communications on hand. And again, Megan will get more into that. But you just keep in mind that Title III of the ADA isn't only about structural modifications. It certainly is. It is about how high a light fixture has to be or where the handicap signs around the property need to be placed. But the ADA in general is a civil rights law that expands beyond those issues and really tries to hone in on the policies, procedures, and entire function of your organization to ensure that guests with disabilities have an equal opportunity to use the services provided by your store or your property. With that being said, let's talk specifically now about ADA website accessibility. And I'm going to spend 10 minutes on two totally separate aspects of ADA website accessibility, although they end up getting confused a lot. And the first part of my the next 10 minutes will focus on number one. Does your website need to be accessible for users with visual, hearing, and physical impairments? And what that has to do is no regulations currently exist on this issue, but the Department of Justice has emphasized that businesses should make websites accessible to the disabled and has relied on a set of guidelines called the Web Content Accessibility Guidelines, WCAG. So this situation addresses this issue addresses situations where customers with visual or hearing impairments are potentially unable to navigate your company's website because your website is not compatible with screen access software such as JAWS. And as a result, the customer is unable to make an online reservation or view images on your website. So that's issue number one. I will spend about 10 minutes on that. Then issue number two is, does your website need to provide information regarding various accessible features at your property? And this is talking more about hotels. So if you're on this call and you have a store, you have another place of public accommodation that's not a place of lodging, number two isn't going to apply to you. Because number two specifically addresses lawsuits filed by plaintiffs who argue that when they attempt to access a hotel's website and make an online reservation, they can't do so because the hotel doesn't provide them enough information about the property. The scary thing about both of these issues is that it used to be where an individual had to go to your property to potentially have standing to sue. Now, someone likely has standing to sue simply by sitting in their house and looking at your property's website and saying your website does not have enough information. So let me spend a little bit of time on each of these issues. We're going to start here with issue number one. Does my website, or must my website, be accessible for those who have difficulty hearing and seeing? And the answer to this is basically yes. When the 2010 regulations were promulgated, they announced the Department of Justice announced they would issue regulations to address website accessibility. That would have answered this question definitively. But each administration has delayed the issuance of these new regulations. So right now, technically, there are no ADA website regulations regarding visual impairments. So that's where kind of the confusion has come in the past couple of years. But case law has taken over. And a few years ago, you saw some cases go both ways. Now the trend is very, very, very strongly for all cases, all courts and all jurisdictions finding that companies and places of public accommodation must comply with WCAG, at least in some way, shape, or form. It used to be WCAG 2.0, and now it's been revised, and now there's a new standard. It's WCAG 2.1. And I don't want to spend too long boring you with some case law, but it is important that I just go over a few cases. And you might, if you follow this area of the law, you might recognize some of these plaintiffs' names because it's the same plaintiffs who come over and over, you see them over and over. I've had a case against Gill before, and this is probably the most well-known case with Gill versus Winn Dixie. Winn Dixie, for those of you that don't know, is a supermarket, and Gill alleged that he went on the website and he couldn't read anything about the store because its website was incompatible with JAWS. And the court found that the website is heavily integrated with the store and operates as a gateway to the physical store locations. And as a result, not only is the store a place of public accommodation, but the website in and of itself is a place of public accommodation. Yeah, in that case, the judge specifically declined to rule that a website is always a place of public accommodation. But in my practice, that just doesn't come up too often. It's possible, based on that ruling, that if Amazon.com got sued, it might be found to not be a place of public accommodation and then not be covered by these laws. But anytime there's a sufficient nexus, that's the legal word, between a website and a physical place, this case held that will mean that the website is a place of public accommodation. So if you have a hotel that has a website, the website clearly is related to the hotel. There's a nexus, and thus it'll be a very difficult argument to make to say that the website for the hotel is not a place of public accommodation. There's another case that actually went further. This case is a little bit of an outlier in the Eastern District of New York, but this case said we don't even care about the nexus argument. It said as long as you sell or even advertise services or goods for sale on a website, that in and of itself makes a website a place of public accommodation. So if you're in New York, you're really going to have a hard time getting out of the ADA if you're a website. One other case that I wanted to talk to you about is Haynes versus Hooters. And again, I've dealt with Haynes in a few websites, in a few lawsuits already. And what, in this case, the main issue was, can a company that has already been sued for website inaccessibility dismiss a nearly identical lawsuit because they settled the previous lawsuit? And unfortunately for owners and operators of hotels and other places of public accommodation, in this case a restaurant, the 11th Circuit said, we don't care if you were already sued. All that does is preclude the exact same plaintiff from suing you, even if you've entered into a settlement agreement and even if you have a proposed remediation plan in effect. That doesn't do anything for future plaintiffs. So the point here is you need to fix your website as soon as possible, because if you don't fix your website, you're a sitting duck for all other plaintiffs, even if you've already been sued. And unfortunately, I have represented clients who have gotten sued multiple times for same or similar issues under the ADA. So that's why this next slide just says it's critical to take action as soon as possible to ensure your websites are compliant. Just a little bit so you know what I'm talking about here with visual impairment issues. Some of the main issues are when menus are in PDF format. That usually indicates non-compliance with the ADA. If you have pictures and symbols with no written descriptions, if you have video and audio files with no captioning, even navigating a website without keyboard, requiring a mouse to navigate a website is problematic, because that precludes someone who can't use their hands very well from navigating your website. So these are just common website accessibility issues that you should see. You need to figure out if your website has such issues. You know, the flip side of that other slide is that you need to provide text alternatives for non-text content. You need to provide captions. You want to make all functionality available from keyboard as opposed to just mouse clicks. You want to provide a way to pause or slow down timeout features. You know, there's a whole host of things, but these are kind of the main issues I see for the most part. One I didn't say is avoid using color as the only means of conveying information. Similar to the captions, you want to have both written words and you can use color, which is fine. You just also need written descriptions as well. It's a risk if your company is not compliant with WCAG. It is expensive to fix. You have to hire an ADA consultant, and you want legal counsel to preserve privilege. But if you don't hire a company to test your website's accessibility and you don't know whether your website is accessible, you are really a sitting duck for plaintiffs, and then to settle a lawsuit and then have to hire a company to fix your website is going to cost you twice as much money. So it really does make sense to be proactive, to try to implement a remediation plan. I have some bullets here about what you would do specifically to implement a remediation plan, and create a website that is consistent with WCAG as much as possible. For those of you that know these terms, AA compliance is the accepted standard for compliance. It is very difficult to argue that you could not make your website accessibility because it was unduly burdensome. That is a potential defense, but it is very difficult to make that defense, and I wouldn't want to be making that defense. And I mentioned this a minute ago, you want to make sure to retain an accessibility consultant. That's really, if you're in a large company, you might have someone who can do it in-house, but typically this is a specialized function that you need to retain an accessibility consultant, and don't do that without having outside counsel at least be involved, even if it's just tangentially. You don't need the outside counsel billing tons of hours being fully involved, but you need the accessibility consultant to be performing his work under the direction and advice of counsel so that it is privileged. If you get sued the day after the accessibility consultant gives you his report and it wasn't under the direction and advice of counsel, you will have to produce that report, and that is certainly something you don't want to do. But as long as counsel's involved, that will be privileged and you will not have to produce it. Okay, I know I went very quickly through that, and this next portion is even going to be quicker because I want to make sure Megan has enough time. So we are now moving on to part 2 of website accessibility, and this is issues for users with mobility impairments. And this is taken directly from the 2010 ADA regulations. A hotel must make sure that an individual with a disability can make reservations for accessible guest rooms during the same hours and in the same manner as individuals who are not disabled. So you cannot have something on your website that says, for an accessible room, you need to call the front desk. That doesn't work because that means someone who is not disabled can book a book a reservation through your website, but someone who is disabled has to do something differently. That is a per se violation of the regs. You also need to ensure that accessible guest rooms are held for use by individuals with disabilities until all other guest rooms of that type have been rented. So if you have 10 suites and only one accessible suite, that accessible suite needs to be the last one that you sell unless it's specifically already requested by an individual with a disability. When an individual with a disability requests a room, you need to block that room and remove it from all reservation systems. I've seen too many lawsuits where someone gets to the property, they've switched the accessible room, the individual said she had reserved one with a roll-in shower. They say, sorry, we gave that one away, but you have one with a tub, and that ends up resulting in a lawsuit. So you want to make sure that is avoided. Similarly, number 4 here, it's a very, very similar subtle distinction. Guarantee that the specific accessible guest room reserved through the website is held for the reserving customer. If she's able to reserve room 305 with a roll-in shower, that room must be held for her. She may have a reason why that's the room she's requesting. And then the biggest one that I've left for last here is on your website, you must identify and describe accessible features in both the public area of your hotel and guest rooms in enough detail to reasonably permit individuals with disabilities to independently assess whether a given hotel or guest room meets his or her accessibility needs. This is the one that we see the most, the website, the lawsuits arising out of this regulation. At this point, probably 80% of the lawsuits are coming from this. So this final prong of the regulation is crucial. And it makes sense, as I mentioned earlier. It's much easier for someone to bring this type of claim. They can just look from their home and say, oh, we wanted to visit the hotel, but unfortunately we were deterred from doing so due to the lack of information about the hotel's accessibility features on your website. And as of 2-3 years ago, I saw these claims mainly in Florida, Arizona, California, and New York, but now they're everywhere. There isn't a state where these claims aren't being pursued. So it's really become kind of, unfortunately, a nationwide phenomenon. So, of course, that leads to the question, what is enough information? And all day, every day, I advise clients on what enough information is, but there isn't, the regulation doesn't specify it, and there is not a lot of case law. So there's no bright line rule. I can't just tell a client, you have to list A, B, C, and D, and you're fine. It really is property specific. It depends on what features are available at your property, and it's really kind of common sense that the more information you can provide within reason, the more likely you are to be ADA compliant and avoid these types of lawsuits. So you can do this in a bullet point list. If you only provide two bullet points, accessible entrance and accessible lobby bathroom and nothing else, that might not be enough. You don't need 100 bullet points. You don't need to say every outlet in the room is less than 48 inches above the ground, and every you don't need to get into measurements. You don't need to overwhelm the reader, because you have to remember this is someone looking at the website, so it still needs to be in a user-friendly setting. And you want, I've had plaintiffs' attorneys tell me, oh, you hit it, I couldn't see it, or you provided, the font was too small. You want it just like everything else on your website, so it's easily usable and absorbed by the user. But at a minimum, you want to be able to provide information regarding whether the common areas of your hotel are accessible. So you want to say, if it's true that your lobby bathroom is accessible, that your restaurant is accessible, that your pool does have an accessible lift, that there's an accessible route from the entrance to the pool, that there's an accessible route from the entrance to the front desk, that your front desk is accessible. Again, you don't have to say that your front desk has a shelf that's 36 inches wide and 36 inches high, but you at least just want to indicate that it meets accessibility guidelines. And as I said, number 3, you want to talk about the routes as well to make sure someone knows that they can get from one accessible area to a different accessible area. This is typically provided on the hotel, on the home page with a link that says accessibility. And again, it can just be bullet points regarding these common areas. And then You also want to provide sufficient information regarding your rooms. You want to say the bed type, the number of beds, if it's roll-in shower, if it's a tub with a seat. You want to talk about you have grab bars. You want to say if your closets are accessible, if your security latch is the proper height. You do want to talk about that information. And also, along with that, and this is the last thing I'll talk about before I turn this over to Megan, you and some, especially smaller hotels, struggle with this. Once you provide the specific information about various guest rooms, you want to provide a way that an individual can book a room with those specific features. So, for example, if your hotel has a few rooms with roll-in showers and a few rooms with tubs without roll-in showers, your website must provide a mechanism so that an individual can rent the specific room he or she chooses. Similarly, hopefully your hotel has some double bed accessible rooms and some king bed accessible rooms. Your website must provide a mechanism so that an individual can choose which one they want to rent. Quite often for space reasons, properties tell me we only have rooms that are accessible rooms that have king beds. And that's a problem because a lot of individuals with disabilities travel with companions who may not be their spouse and they want double beds. So you need to provide as many options as you can. There's a rule under the ADA called the dispersion rule. And you want to have some accessible suites, some accessible double-doubles, some accessible kings, some with roll-in showers, some without roll-in showers. And again, you need to have a website that enables an individual to choose that specific room. And the final thing I'm going to say here before I turn it over to Megan is the ADA went into effect in 1992. So there are slightly different requirements about the level of specificity for ADA compliance if your hotel was built before 92, after 92, or after 2010. But I hear too much from clients, oh, we don't have to worry about the ADA. We're grandfathered in. We're an old property. The ADA doesn't apply to us. I don't know where that rumor got started, but just so you know, that is just not a thing. The word grandfathered in is not applicable in any way, shape, or form. The standard might be slightly different, readily achievable versus maximum extent feasible, but it is not, there's nothing that absolves a property or any sort of place of public accommodation from complying with the ADA, either at their property or on their website. And with that being said, I am going to turn it over to Megan for the remaining portion of the presentation.
Thanks, Jordan. Hi, everyone. So moving on to service animals, as we've been discussing, the ADA requires places of public accommodation to provide reasonable modifications to their policies and practices when necessary to accommodate people with disabilities. So how does this apply to guests using service animals? The first question, of course, we ask is, what is a service animal? Because there are different definitions under different regulatory schemes. And under the ADA, a service animal is a dog or miniature horse, actually, which is trained to perform work for the benefit of a person with a disability. So it's not simply, they have to actually be trained to do a specific task for the person. And what does this mean in terms of making adjustments to those policies as we've been discussing? Well, the surcharge that a hotel or a resort might charge for, a pet fee or a cleaning fee should not be imposed for people using service animals. So the question sometimes arises, okay, well, how do I know if a person coming in has a service animal? Well, if it's not obvious, there are only two questions that can be asked. One is the animal required because of a disability? And the second question that's permitted is what work or task has the animal been trained to perform? No other questions about either the individual's disability or the animal are permitted. So you don't want to ask for proof of certification that the animal is a service animal. There's no such thing under the ADA. You don't want to ask for any medical documentation that the individual has a disability. That said, there are some restrictions placed on the person using the service animal that gives you some ability to maintain order in your establishment. You can require, generally, you can require the animal be harnessed, leashed, in the control of the person using that service animal. So if an animal is really out of control and the owner can't get that control back, or the dog isn't housebroken in the facility, then you can ask the person that the animal not be in the facility. We get questions a lot about emotional support animals or comfort animals, and because those animals are not specifically trained to perform a task for the individual, they do not fall under the ADA's definition of service animal. We've had situations where people have wanted to leave their comfort or support animal in the hotel, and that again is another indicator that animal is not a service animal, as the service animals need to be with their individual at all times. That is the gist of the rules on service animals. Another hot topic is how the ADA applies to food allergies. Food allergy can and has been considered a disability under the ADA. A disability under the ADA is a mental or physical impairment that substantially limits a major life activity. So allergies can apply if a major life activity such as eating is affected. The answer is oftentimes going to depend on on the nature of the allergy and also how severe it is. In particular, if you think of allergies that can come with significant symptoms like difficulty breathing or difficulty swallowing or anaphylactic shock, those are going to be more likely to be considered a disability under the ADA. So what does that mean for us? There was a Department of Justice investigation back, it started in around 2009, resulting in a settlement in 2012, and it involved a complaint involving Lesley University, which is a private college in Massachusetts. There was a complaint that the mandatory food service meal plan required for students living on campus was a violation of the ADA because it failed to make reasonable modifications to the policy to permit students with celiac disease and other food allergies from fully enjoying the benefits of its food service plan. So we care about this settlement because if the premise of the Lesley University decision were applied broadly, it could have far-reaching implications for those in the providing food service. In the settlement in that case, there were quite a few specific modifications to the policy that were requested. So it was a mandatory policy, and it applied to all students living on campus. And the Department of Justice wanted food options to be provided to students so that when they went to the campus dining hall, they had options to eat. So they could not only eat, which they were paying for, but they could also enjoy the social experience of being in the dining hall with all the other students. They wanted reasonable steps implemented to avoid contamination, meaning, a particular area of the main dining hall kitchen so that food preparation could be done without the risk of contamination with high allergen foods. They wanted the university to sit down with those with allergies and develop an individual plan for those students, so that they would know the allergies that were a potential issue and be able to figure out what would make sense, how to change what was being offered in order to accommodate that student. They wanted students to be able to pre-order meals if they needed to with 24 hours notice. And of course, they wanted records of all of the allergies, and they wanted training for all managers and staff. So the goal for all of us to keep in mind is, when it comes to food allergies, is just to think about what your business is offering in terms of food service. Think about how the customers may be able to enjoy that experience or may be restricted from enjoying that experience. And then thinking through, based on the specifics of your situation, what you could maybe do to improve. For you can start thinking about these improvements. There's not going to be a one-size-fits-all situation. And things you can think about from the start is communication. Are there ingredient legends you can have for foods being provided so that guests know what's in the dishes? Are there allergen warnings you can have? Are there notifications you can include in written materials or signage that reminds guests to let us know if there's a food allergy so that adjustments can be made if possible? You can take it a step further and think about, is there a way for you to provide allergy-free foods? Are there a way for you to adjust your policies and procedures for how you deal with this? Are there vendors you could work with that would easily allow you to provide allergen-free foods if you're not currently providing them or not able to provide it in-house? Again, the best approach that we can recommend is just to be really proactive about this. Since there aren't clear-cut rules in this area, it's good to think about what can you do from a proactive standpoint, from a transparency standpoint, and with the ultimate goal of providing good customer service to your guests. On the kind of opposite extreme of the Leslie University situation, there was a lawsuit filed against P.F. Chang's when they had instituted a $1 surcharge for its gluten-free menu items. There was a class action lawsuit that tried to prevail on a claim that the surcharge violated the ADA because it was forcing those who cannot eat gluten to pay more. The court ultimately dismissed the case. One of the explanations they gave is that the surcharge applied across the board. It wasn't just those with gluten-free diets because of allergic reactions. It applied to people who just chose the gluten-free option. So it wasn't specifically discriminating against those with food allergies or with celiac in particular. Just thinking more about what a restaurant could do. All of these things are going to be on a spectrum depending on what your business looks like, what would be easier, what would be more difficult. But taking reasonable steps to think through what could be done. Again, make sure that your staff knows about this as an issue, knows about the food so they can answer questions from diners. See if there's a way to omit or substitute ingredients upon request. If every dish is being made fresh for every order that comes in. Maybe that's a situation where an easy adjustment could be made if a request were made, and maybe you even put that on the menu that modifications or requests can be made. That covers the area of food allergies. The last main topic that we want to cover in this presentation is effective communication issues. Jordan mentioned this early on, that this is where accommodations can be made for somebody with hearing or visual impairments. So we've seen a lot of lawsuits claiming that a guest at a hotel, either a guest staying at the hotel or a guest attending an event at the hotel, was denied access because they were denied an assisted listening device. So we've seen this both by people trying to stay at the hotel, that they wanted accommodations with communication devices in the room, and we've also seen it with people attending seminars. So if your hotel or resort has meeting rooms or has big conference rooms or hosts big events, this is definitely something to keep in mind. And then even for anyone staying in your hotel, we had one case in particular where, as it says here, the plaintiff could not remember going to a hotel for a seminar or a meeting or a conference and not suing that business, not suing that property. So this just tells you that a lot of businesses are unprepared for the requests, and that there's definitely steps everybody could be taking to be more prepared for these lawsuits and to be more prepared to accommodate the needs of the guests. This is all stemming from a regulation under the ADA specifying public accommodation shall furnish appropriate auxiliary aids and services where necessary to ensure effective communication with individuals with disabilities. So there are specific devices and systems that I can mention in a couple of slides, but the idea is that that the auxiliary aids are going to depend on what the guest is trying to accomplish. So if somebody is attending a seminar, there may be different assisted listening devices they may need versus somebody who's staying in a hotel room. It also depends on what the impairment is and what the communication is necessary. Is somebody just trying to hear a seminar, or is somebody trying to communicate with somebody on the other end of a phone line and needs to be able to both understand what that person is saying and be able to communicate in response? So examples of auxiliary aids and services includes everything from open and closed captioning, where you have a transcription of the dialogue on the screen, transcription services, maybe in a restaurant, if you have somebody who can't communicate out loud with words, you have somebody who can, write a quick note and communicate with a person like that. Or if you have, a big conference room and big presentation being performed, maybe you need to get somebody in to do translation for those in the audience who may have audio impairments. You have telephone, handset amplifiers. You have devices that will amplify sound for people who use hearing aids in a conference or seminar setting. You have interpreters. There's lots of different methods depending on the needs of the person. So you want to really engage with the guest, determine what the needs are, and then determine what aid may be needed and may be helpful for that person. It's good to think through this before you actually get a request so that you can be prepared, not only have a policy and procedure in place for providing them, making sure that anyone who interacts with members of the public understand the policy, understand what to do, and then identifying if there are devices that you can have on hand. Can you have a text, telephone, in your ADA room? Can you have a text telephone behind the front desk that you can bring out if necessary? Or do you need to have maybe a vendor that you can call if you need services for a big seminar coming up? Can you easily find out how to produce a document in Braille or acquire any other aids or services? It's really, the training piece of this is really, really important, because you may have, a manager who knows what to do, but if that manager isn't the person that interfaces with every member of the public, you could have a situation like we had in a recent case where somebody came in off the street, asked if there was a room available for that night, was told there was vacancy, was told the rate, and then at the last minute the person threw in, very quickly under his breath, I might add, "Do you have a TTY phone?" And the person at the front desk had a difficult time, didn't know the answer, said, "Oh, the manager's not on site right now. I'm not sure. I think we might." Kind of seemed to leave the door open, but it wasn't enough, and that person turned around, didn't take the room, and sued the property for failure to accommodate. So there are definitely steps you can take in all of these areas to be more prepared for these requests, to be more prepared for these issues, and do your best to reduce your risk of getting hit with one of these lawsuits. It does take us to the end of the slides.
Our contact information's right here. Megan and I, do this all the time. We like hearing from you all. So if you'd like, feel free to email us with any questions you have. We'll be happy to respond. We will get the slides to you, so you have the slides in the next few days. Please reach out to us with any questions you have. Also, this is our blog, the Employer Defense Report. We write about this stuff all the time. There's this and lots of other issues that affect whatever industry you're in, and it might make sense to just check out that blog, sign up. We probably write articles about once a week. It's free, and you'll just get them sent directly to your inbox, so it's just a good thing to keep apprised of the law. And with that being said, thank you very much for attending, and we look forward to speaking with you on a different topic very soon.